Greetings, my fellow free sovereign thinkers. Thank you for tuning to the LL3 podcast. My name is Craig, transmitting from the beautiful realms of planet Earth. Today's date is Monday, March 23rd, 2026. This is episode 1951, When Judges Go Rogue. Before I proceed, you can follow me on multiple social media sites and podcast channels. Just type in Looky Luck number 3, Looky Luck Roman number 3, 3 eyes, or the Looky Luck Roman number 3 podcast. Furthermore, if you have any questions, comments, recommendations, all that good stuff, whatever you do, please use decorum. Hit me via email to ll3.podcast@proton.me. If you want to donate, go to PayPal to me or Cash on app /Looky Luck number 3. This article here caught my attention. We've been seeing a lot of the finaglism in the judicial branch of government, whether it's federal or state. So I'm going to be reading this one here from the Brownstone Institute, which is brownstone.org. When Judges Go Rogue by Bonnie Ann Flower Cox. So kick back, and we'll take it from here. As it reads, though I am an attorney in practice for almost 30 years now, I have always said that not all issues can be resolved in a court of law. I say this because I lack confidence in our judicial system. But because not all issues are subject to the decision of the court. In other words, judges can't have a say in everything. This is the premise behind our stalwart foundational doctrine of separation of powers, where each of our three co-equal branches of government have their own sphere of influence and power, and each is to stay out of the other's lanes. To the point, some issues are policy issues, not legal issues, and so just as the executive branch, the president and his cabinet, cannot adjudicate a dispute between you and your neighbor, nor can a judge nullify an agency's lawfully permissible actions just because the judge doesn't like what the agency head has done. Furthermore, there's a hierarchy to our judicial system in the United States and in the federal court arena. The district courts are the lowest on the totem pole. Everyone in the legal world knows this. Attorneys, court personnel, legal scholars, and unquestionably above all others, the judges know this. However, there is a new phenomenon growing in our country which can be categorized as nothing short of lawlessness. There is a class of judges who feel so emboldened they believe they have the authority to bestow upon themselves a supernatural power to trump the Constitution and go it their own way, so to speak. Those rogue judges are a clear and present danger in our society, for they ignore our 250-year-old rules and instead write their own playbook. To borrow a term from the left, which is rather ironic considering these cagey judges were almost all appointed by Democratic presidents. These judges are a threat to democracy. Call them activist judges. So I'll continue on. In response to this growing brazen disregard for law and order, our highest court in the land decided it had to step in and set the record straight. Like naughty children who refuse to obey their parents, the United States Supreme Court SCOTUS gave the rogue judges a stern reprimand that left no room for interpretation. To be exact, in June of last year, SCOTUS issued a decision that made it crystal clear, that the federal district court judges, i.e. the lowest court in the federal judiciary system, are limited in their reach. More specifically, in Trump versus Casa, SCOTUS ruled that these district court level judges can only issue injunctions that are binding on the specific parties in that case. I analyzed this decision in more detail in an NTD interview shortly after the decision was released last summer. The bottom line is these lower courts, of which there are almost 100 in our country, cannot issue decisions that affect the entire country. That power lies only with SCOTUS, as it should. Remember, folks, our Constitution only establishes the Supreme Court. All other courts are subservient thereto, and therefore must be obsequiously submissive by their very definition. And yet I got a phone call on March 16th from a colleague, though not a fellow attorney, who was clearly agitated, and I could probably say close to irate by the end of the call. He barely greeted me when I picked up the phone, and he dove right in with, "Did you hear about this stupid ass judge in Massachusetts who just threw out Kennedy's ACIP panel and validated their changes to the childhood vaccine schedule? What the hell is going on? He can't do that, can he?" I hadn't yet heard about the decision, so I immediately thought to myself, this colleague's got it wrong. There's absolutely no way a judge in Massachusetts can toss out the HHS Secretary's appointees to ACIP, which is ACIP, and undo the work they've done. As my colleague was huffing and puffing about it, I remained very calm, which confused him. Why are you upset about this?" he asked me. So I told him with great confidence that I was sure he got the story wrong. But even if he got the story right, no judge sitting in Massachusetts has the power to do that. So if the judge was absurd enough to issue such ruling, it's illegal and it will be overturned. Of course, once we hung up the phone, I searched online and read a couple of news stories to see what was being reported on it. Here's what the Hill news outlet wrote. A federal judge on Monday blocked Human Health Services, or HHS Secretary Robert F. Kennedy Jr.'s changes to vaccine policy, including a reduction of the recommendation childhood immunizations and his remaking of a key vaccine advisory panel. U.S. District Judge Brian E. Murphy, a Biden appointee, granted a motion by the American Academy of Pediatrics for a preliminary injunction against reduced childhood immunization schedule earlier this year, with the remaking of the Advisory Committee of Immunization Practices for the Center for Disease Control and Prevention, invalidating all votes made by the committee since. The article noted Murphy's rationale pointed out that he found that the CDC bypassing the ACIP when changing the childhood immunization schedule was both a technical and procedural failure and an abandonment of the technical knowledge and expertise embodied by that committee. In an even more stunning move, Murphy then personally analyzed the members of ACIP one by one, naming them by name and decrying how unqualified they were. Read that again, folks. The judge critiqued each member of the panel that the HHS secretary is permitted to appoint, and the judge decided that each person was not qualified to sit on said panel. Murphy put his God hat on and decided that although the ACIP appointees were indeed experts, some members of ACIP appear lack of any expertise or professional qualifications related to vaccines or immunization as required by ACIP's charter. Of other ACIP appointees, Murphy declared, though they have some experience arguably relevant to ACIP's function, appear to the lack the qualifications and experience to constitute expertise in vaccines and immunizations. It's honestly mind-blowing. This judge literally substituted his opinion on the medical experts that sit on ACIP and their professional decisions regarding which vaccines were necessary, at what dosages, and at what ages, for the opinion of the duly appointed HHS secretary. It is not a role of a court Judges are not supposed to legislate from the bench, as legislation is a power bestowed upon Congress, legislative branch, which is Article 1 of the U.S. Constitution. Nor are judges allowed to be governed from the bench, and that is a power bestowed upon the executive branch, president, and cabinet, which is Article 2 of the U.S. Constitution, and Article 3 is judicial. So, and there's a list on here too, with the District Court of Massachusetts. Gives you a preliminary hearing on that case. So, you can actually see this for yourself. With the civil action suit. Let me see here. So, it does exist. When I read Murphy's decision itself, I read it with a great mixture of awe, not in the positive way, and disgust. The bottom line is that a judge is quite frankly ignorant. From many fronts, he's ignorant for not knowing that the separation of powers makes this topical non-justifiable. He's ignorant for ruling as he did, of course, presuming a court actually has the power to adjudicate this issue. Here's what struck me as I analyzed the 45-page decision. First, I recognized this clown's name. There cannot be two federal district court judges from Massachusetts named Brian E. Murphy, so I looked him up to confirm. This was the same guy who defied a SCOTUS order that in essence stopped Murphy from staying deportation orders last year. Even radically liberal Justice Kagan scorned this Dumbo Murphy for his brave and disregard for SCOTUS power. Wow, isn't that amazing or what? So, we are dealing with the guy who already thinks he's above our nation's highest court. Wow. Second, Murphy's procedural background section of his decision, the part where the judge lays out the lawsuit's history up until that point, noted that were 4 amended complaints in this lawsuit, and he allowed all of them. Understand that it's not that uncommon for a plaintiff to amend their complaint. That's the technical name for the document that commences a lawsuit. However, you will usually see 1, maybe 2 amendments once a case is filed, but 4? Definitely not normal. And especially when each of the amendments to the lawsuit substantially changed the nature of what is being challenged in the case, as happened here. According to Murphy's written decision, the final complaint, after 5 tries, challenges. Plaintiffs now challenge 1, Secretary Kennedy's May 2025 order that the CDC removed its recommendation that pregnant women and healthy children receive the COVID vaccine. 2, the reconstitution of ACIP. 3 votes ACIP took in 2025. And 4, Director O'Neill's January 2026 memorandum revising the CDC's childhood immunization schedule, collectively the challenge actions. Alarm bells should be going off in your head right now because judges can't adjudicate these things. It just doesn't work like that. The HHA security did something wholly within his power and was furthermore carrying out a directive given him by the president to study our country's childhood vaccine schedule and compare it to other similar nations' schedules. And if we are out of step, which we are, then fix it. A notable sidebar. Last December, Secretary Kennedy reported President Trump directed us to examine how other developed nations protect their children and to take action if they are doing better. After an exhaustive review of the evidence, we are aligning with the U.S. childhood vaccine schedule with international consensus while strengthening transparency and informed consent. This decision protects children, respects families, and rebuilds trust in public health. According to HHS, the assessment reviewed 20 peer-developed nations and found that the U.S. is a global outlier among developed nations in both numbers of diseases addressed in its routine childhood vaccination schedule and the total number of recommended doses, but does not have higher vaccination rates than such countries. In fact, many peer nations that recommend fewer routine vaccines, achieve strong child health outcomes, and maintain high vaccination rates through public trust and education rather than mandates. For example, in 2024, the U.S. recommended more childhood vaccines than any peer nation, more than twice as many doses as some European nations. At the lower end is Denmark, which immunizes children against 10 diseases compared to a total number of 18 for which protection was provided in 2024 in the U.S. Some American children are required to get over 70 shots in order to be allowed to attend school, and yet Secretary Kennedy cites our children as no healthier than peer nations' youth, and for sure the sickest generation yet. Third, there's no way the American Academy of Pediatrics has standing to bring this lawsuit, and yet Murphy ruled twice that it does. The Academy has zero legitimate injury that it would sustain as a direct result of Kennedy's actions. Remember the premises behind the standing. If you don't have a direct injury from a defendant's actions, you don't have the right to sue them. For example, if you steal my car, then I can sue you for the loss. But if you steal my mother's car, then I don't have the right to sue you for the loss. But my mother would. Furthermore, an injury must be legitimate. For example, if criminal A is selling stolen goods and criminal B comes along and steals criminal A's stolen goods and starts selling them on his own, then criminal A doesn't have the right to sue criminal B to get his stolen goods back. Looking at the case at bar, ACIP members being replaced or certain vaccines being removed or modified from the childhood schedule does not directly harm the Academy, other than perhaps loss of seemingly unethical corporate cronyism, but I emphasize legitimate injury. You can check out the Academy's list of top corporate donors here. There's a list. You can see it for yourselves, folks. I'll just let you see the link. I will leave the footnote on this on my episode so you can see it for yourselves. Funny how they are basically drug manufacturers. What does that say about the Academy, whose mission has posted on its website to promote health of children by supporting the needs of its members? Moreover, what it does say, what it says about the judge who twisted himself into a pretzel to rule twice, that statement is proper. See pages 25 to 26 of the decision if you want to read his nonsensical explanation. For those of you who follow my work, you will recall that my epic quarantine camp lawsuit victory against the tyrannical governor of New York and her lawless Department of Health was disgracefully and illegally overturned on the appellate court's shaming standing rule. If my sitting NYS State Senate and Assembly members don't have the standing to challenge the usurpation of their constitutionally endowed lawmaking powers by the governor and her minions in her health department, but the seemingly captured American Academy of Pediatrics has standing to challenge who the HHS director puts on his ACIP panel and how many vaccines they recommend children receive, then you should duck hard because pigs can fly now. Now fly. The final truth bomb that jumped off the pages at me when I read this embarrassment of a legal ruling was a judge's noting of the holy grail of today's broken healthcare system, and that is the almighty dollar. Murphy points out, page 13, the sparsely discussed fact that vaccines recommended by ACIP enjoy the cushy benefit from being paid for by the government with our tax dollars, of course. So someone can get all the shots they want, but if the shot isn't listed on ACIP's schedule, then it's not free to the consumer. They will have to pay out pocket. Surely sales would plummet if the public had to open their wallets every time they or one of their children needed a shot. Then there's the other thinly reported fact that the drug manufacturer's liability shield for injuries sustained by the public for taking a vaccine only extends to those shots that are listed on ACIP's recommended schedule. Murphy skims over this around page 12 as it's an afterthought. Moreover, he couches it in such a way as to try to make the fact work for him in his argument against Kennedy's and ACIP's actions. Here again, we see at center stage the holy grail of our pathetically captured healthcare system, the almighty dollar. If the manufacturers, many of whom financially support the economy, will all of a sudden be subject to liability for the vaccines they make, then they will surely get slammed with injury lawsuits. Could this be the entire point of the Academy's lawsuit in the first place? If so, then standing is even more clearly lacking. A notable sidebar: drug manufacturers are liable for the medicines they make, but they aren't liable for the vaccines they make. You can thank Congress for that. Both that one made to law in the 1980s and one today who refuses to change that law. And there's a conclusion on that right there. You can see it for yourselves on this conclusion. So, insane, right? Bottom line, Murphy's ruling is not only in his decision an absurd abomination of law, but is also totally impermissible as a violation of judicial restraint. A judge, and especially a district court judge, doesn't have the power to invalidate the decision of an executive branch agency when those decisions are discretionary and within the stated power said agency. Separation of powers is the cornerstone of our free nation. The fact that a wily federal trial court judge thinks he can undo 2.5 centuries of our United States Constitution because he doesn't like what a member of the president's cabinet is doing is, in the word, ignominious, yep, said to say the least. And this was republished on her Substack, but this is a good article from Miss Cox. And he got to be very honest because we've been warned about this a very long time. And Thomas Jefferson, I'm going to leave an article. I'm going to leave a little article here on by the 10th Amendment Center on judicial tyranny. And some of the areas I'm not going to go too overboard, but I'll say some of the quotes. He said that judicial tyranny made the Constitution a thing of wax. Jefferson was plainly alarmed by the possibility of judicial tyranny. All right. And I'll give you some letters in here. I'll maybe write a couple here. Like one right here. Jefferson plainly had an answer against judicial tyranny. The case of Marbury and Madison is continually cited by the bench and bar if it were settled law without any animadversions of it being merely an arbiter dissertation of the Chief Justice. But the Chief Justice said, there must be an ultimate arbiter somewhere. True, there must. But the ultimate arbiter is the people. That was a letter to William Johnson in June 1823. He saw the judicial tyranny was leading. And here's another quote here, another letter to C. Hammond on July of 1821. When all governments, domestic and foreign, in little and in great things shall be drawn to Washington as the center of all power, it renders the powerless the checks provided of one government on another, and will become as venal and oppressive as the government from which we separated. So he gives that's in 1821. And he's right here. He saw the judicial tyranny as the greatest danger to the nation. There is no danger I apprehend so much as the consolidation of our government by the noiseless and therefore unalarming instrumentality of the Supreme Court. That was to William Johnson, March of 1823, and one more for the judges to usurp power of the legislator is unconstitutionally judicial tyranny. One single object will entitle you to the endless gratitude of society, that of restraining judges from usurping legislation. That's a letter to Edward Livingston, March 1825. There's a lot of good amount of quotes in here. I will definitely leave this footnote on here as well, so you can folks can check it out. And this is why we have to have the balance of power, separation of powers, or balance of the federal government. That even works in the state level as well, in your state constitutions. So please, my friends, I encourage everyone to start reading these things. Beware of these activist judges, especially if you're a juror. With the ones presiding will have those attributes, totalitarian attributes to be exact. And here's the thing: you are the most powerful people in the courtroom, each juror, and the judge is only a mediator. Nothing more, nothing less. If he give you instructions which you believe is unconstitutional, you can nullify them during deliberation. And I digress. So let's study the history lessons of judicial tyranny, which Jefferson warned us on. And always be aware of these activist judges. They do contaminate space. But we got to keep pursuing, keep enduring to counter their propaganda machine, regardless who they appointed from, Democrat, Republican. You got these geniuses. They are smarter than everybody, smarter than their oath of position. So that will be it. Thank everyone for listening. Plus, feel free to download and share it throughout your social media networks. If you have any questions, comments, recommendations, all that good stuff, whatever you do, please use decorum. Hit me via email to ll3.podcast@proton.me. If you want to donate, go to PayPal.me or cash.app/logic3. If you want to support the Brownstone Institute or the 10th Amendment Center, that'd be great. There's links for that on these footnotes, so you could take the initiative and check it out yourselves. All right. Once again, thank you for your time. Plus, always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.